Welcome to the training module for the city's purchasing policy. The city's charter requires in Section 5.06 the City Council shall by ordinance prescribe procedures for a system of centralized purchasing for the city in accordance with recognized public purchasing standards and the requirements of state law. Over the next few minutes, we will review the components of the city's adopted policy. The purpose of this policy is to state the city's position regarding the purchasing responsibility and authority of non-construction goods and services. This document will clarify purchasing functions and outline purchasing policies, as well as describe departmental relationships, responsibilities, and participation in the procurement cycle. This policy will provide control functions, assure proper record-keeping, and confirm purchases in writing to allow the city to meet the following goals. Maintain at all times and under all conditions a continuous supply of goods and services necessary for the operation of the city. Encourage and promote fair and equal opportunity for all persons doing or seeking to do business with the city. Safeguard the quality and integrity of the city's procurement process. Ensure compliance with laws and regulations pertaining to the procurement of goods and services. Manage procurement and inventories of purchased goods to meet the use requirements of city departments at the most advantageous cost to the city. Administer procurement contracts and contract amendments. Properly dispose of all material and equipment declared to be surplus or obsolete, and ensure the city provides quality service to our citizens and support the largest economic engine in the Southeast by planning in a careful and thoughtful manner. In addition, this policy is to set a standard of environmentally preferable procurement and demonstrate the city's commitment to environmental, economic, and social stewardship. The city has a unique opportunity to further expand its leadership in the area of environmentally preferable purchasing, and through its actions, elicit changes in the marketplace. By further incorporating environmental considerations into public purchasing, the city will positively impact human health and the environment, remove unnecessary hazards from its operations, reduce costs and liabilities, and improve the environmental quality of the region. This policy will guide the city's efforts in procuring environmentally preferable goods and services. The philosophy behind this policy is one of separating the need for goods and services from the function of negotiation and executing the necessary contractual purchase agreement. The purchasing policy outlined herein shall be used in conjunction with the Procurement Card Procedure Manual. The scope of this purchasing policy covers the procurement of most goods and services for non-construction purposes without regard to the past method by which the material or service has been or is customarily procured. The policy covers all contractual and purchase agreements between the city and another person. The procurement function includes the initial agreement purchase, changes and/or renegotiations. This policy establishes the specific responsibility and authority of the procurement of materials and services. As part of the audit process, the internal controls and accounting processes outsourced municipal services vendors will be evaluated and a measure of assurance given as a requirement of completion of the city's annual audit. The staff of outsourced municipal services vendors assigned to work at city offices and perform purchasing activities on behalf of the city is not exempt from the city's adopted purchasing policy. Furthermore, unless due to the lack of competitive options, the city will not typically procure goods and services from outsourced municipal services vendors not expressly stated in their contract to provide municipal services or do not have a direct impact on the vendor's ability to provide those contracted services. The provisions of this policy do not apply to procurements for the following: public works construction contracts to the extent governed by OCGA Section 36-91-1 et sequentia. Services and construction whose procurement falls under a conflicting federal or Georgia statute. Land, artistic work, or other good whose inherent nature is unique and cannot be competitively compared to other goods within its class, except as provided in Section 8, Real Estate Acquisition. Employee benefits and health-related services procured through a quotation and negotiating process conducted by an expert in the field, or to maintain continuity of employee health records. Travel, entertainment, conferences, training, speakers, instructors, facilitators, and meeting expenses or other expenditures covered by another city policy. Insurance procured through a negotiating process, items or services procured for resale or to generate a revenue, advertising, subscriptions and dues established during the budget process, utilities, and seized property including in a court order authorizing disposal. Employee conflicts of interest. It shall be unethical for any city employee, official, or agent to transact any business or participate directly or indirectly in a procurement contract when the employee or official knows that the employee, official, or agent, or any member of the employee, official, or agent's immediate family has a substantial interest or financial interest pertaining to the procurement contract, except that the purchase of goods and services from businesses which a member of the City Council or other city employee has a financial interest is authorized as per OCGA Section 36-1-14, or the procurement contract is awarded pursuant to OCGA Section 45-10-22 and Section 45-10-24, or the transaction is accepted from said restrictions by OCGA Section 45-10-25, interpreting such statutes as if they were applicable to a municipality. Any other person, business, or organization with whom the employee, official, agent, or any member of an employee, official, or agent's immediate family is negotiating or has an arrangement concerning prospective employment is involved in the procurement contract. An employee, official, agent, or any member of an employee, official, or agent's immediate family who holds a substantial interest or financial interest in a disclosed blind trust shall not be deemed to have a conflict of interest with regard to matters pertaining to that substantial interest or financial interest. Vendors may be asked to sign a disclosure document indicating any connection to or with a city employee or elected official. Gratuities, rebates, or kickbacks. Gratuities. It shall be unethical for any person to offer, give, or agree to give any city employee, official, or agent, or for any city employee, official, or agent to solicit, demand, accept, or agree to accept from another person a gratuity, rebate, or an offer of employment in connection with any decision, approval, disapproval, recommendation, or preparation of any part of a program requirement or a purchase request influencing the content of any specification or procurement standard, rendering of advice, investigation, auditing, or in any other advisory capacity in any proceeding or application, request for ruling, determination, claim or controversy or other particular matter pertaining to any program requirement or a contract or subcontract, or to any solicitation or proposal, therefore, in any manner inconsistent with the State of Georgia's Department of Administrative Services gratuity policy. Rebates normally or routinely offered to all customers for the purchase of their goods and services are acceptable and are the property of the city. Nothing in this section shall preclude an official, employee, or agent of the city from attending seminars, courses, lectures, briefings, or similar functions at any vendor's facility or at any other place if any such seminar, course, lecture, briefing, or similar function is for the purpose of furnishing the official, employee, or agent with knowledge and information relative to the vendor's products or services, and is one which the city manager determines would be of benefit to the city. In connection with any such seminar, course, lecture, briefing, or similar function, nothing shall preclude the official, employee, or agent from receiving meals from a vendor. Nothing in this section shall preclude the official, employee, or agent from receiving educational materials and business-related items of not more than nominal value from a vendor. Nothing contained in this section shall permit the official, employee, or agent to accept free travel from the vendor outside the state of Georgia or free lodging in or out of the state of Georgia. It shall be unethical for any payment, gratuity, or offer of employment to be made by or on behalf of a subcontractor under a contract to the prime contractor or higher-tier subcontractor or any person associated therewith, as an inducement for the award of a subcontract or order. The prohibition against gratuities, rebates, and kickbacks prescribed in this section shall be conspicuously set forth in every contract and solicitation documents therefor. Employees may accept for themselves and members of their families common courtesies usually associated with customary business practices, so long as a strict standard is enforced with respect to gifts, services, discounts, entertainment, or consideration of any kind from suppliers of merchandise, services, supplies, etc., to the city. An example of a common courtesy is free pens or notepads with the vendor's name on them. It is never permissible for a city official, employee, or agent to accept a gift in cash, cash equivalents, stocks, or other forms of marketable securities of any amount. It shall be unethical for a person to be retained or to retain a person to solicit or secure a city contract upon any agreement or understanding for a commission, percentage, brokerage, or contingent fee, except for retention of bona fide employees or bona fide established commercial selling agencies for the purpose of securing business. It shall be unethical for any city employee, official, or agent knowingly to use confidential information for actual or anticipated personal gain, or for the actual or anticipated personal gain of any other person. No purchases of goods and services shall be made in the name of the city or one of its departments, except such as is required for official use by the city or one of its departments. Purchases in the name of the city or a department for personal use by an individual or for other than official use are prohibited, and no city funds will be expended or advanced therefor. The City Council may take appropriate legal and/or disciplinary actions pursuant to the city's ethics ordinance against any city official or person in violation of these ethical standards for any employee under their direct supervision and control, subject to the appropriate appeals process of the city. The city manager may take authorized and appropriate legal and/or disciplinary actions, including dismissal against any city employee. The city manager may impose any one or more of the following penalties or sanctions on a city employee for violations of the ethical standards in this section as appropriate to the situation, subject to the personnel manual or other appropriate appeals procedures: oral or written warnings or reprimands, suspensions with or without pay for specified periods of time, termination of employment. The city may impose any one or more of the following penalties or sanctions on a vendor or other person or organization for violations of these ethical standards: written warnings or reprimands, termination of contracts, debarment or suspension. The City Council may appoint the city manager or said agent appointed by the city manager to serve as the purchasing agent for the city, or the council may contract with an independent third party to serve as the purchasing agent. Duties. The purchasing agent shall have the following duties and powers: arrange and negotiate the purchase or contract for all equipment, supplies, and contractual services for the city or any using agency. Arrange and negotiate for the sale or otherwise dispose of all surplus equipment and supplies or real estate of the city or any using agency. Maintain a perpetual or periodic inventory record of all materials, supplies, software, or equipment stored in city storerooms, warehouses, and elsewhere, including monthly reports to the finance director that include titles of all formal solicitations and the method of source selections to be used, contracts authorized by the City Council, the method of source selection used, and the total dollar amount, emergency contracts awarded pursuant to Section 1.03 of the city's charter, change orders or contract modifications authorized by the council and the dollar amount and reason, change orders or contract modifications authorized by the purchasing agent and the dollar amount and reason, explanation of any changes and the costs involved in the scope of services made between the time a contract is awarded and the time that the contract is authorized by the City Council. Documentation of the types, quantities, and dollar amounts of environmentally preferable goods, including the percentage of post-consumer and total recovered material content and services purchased. The report shall also include dollar amounts of non-environmental or conventional goods and services, identify and discuss instances where this policy is waived or its requirements found impracticable, and highlight barriers to the procurement of environmentally preferable goods and services, if applicable. Manage and supervise purchasing staff, control and supervise all city storerooms and warehouses, develop and maintain a purchasing policy and procedures manual which will be updated by city manager or their designee periodically. Establish guidelines within the purchasing policy and procedures manual governing the review and approval of specifications for procurement of goods and services based on recyclability, energy and water conservation, life cycle cost, and other environmental considerations. Direct efforts to procure goods and services through advertisements of bids in the local legal organ as required by the city's municipal code and by state law. Direct efforts to procure goods and services through advertisements of bids in the local legal organ as required by the city's municipal code and by state law. Require bonds, insurance, and other forms of protection for the city on the process of procuring goods and services for the city. Terminate solicitations for bids for any good or goods or services when, in the opinion of the purchasing agent, it is in the city's best interest to do so. Reject any and all bids when, in the opinion of the purchasing agent, it is in the city's best interest to do so. Consult with the city attorney if a contracting party breaches or is reasonably anticipated to breach its contract with the city. Assist in negotiating city contracts as directed. The City Council shall approve final contracts and amendments valued at $50,000 and above, and execute and bind the city to such agreements. Contracts and amendments valued between $10,000 and $50,000 shall be approved and signed by the city manager or designee following advance notice to Council via email. Council shall respond within and up to 24 hours of such notice, and should the majority of the members not be in agreement with said contract approval, the contract shall be placed on the next earliest City Council agenda for consideration and approval. Advise the Finance Director and City Manager on the status of negotiations, as well as contract provisions and their impacts on the city. Make recommendations on contract approval, rejection, amendment, renewal, and cancellation. Provide contract administration and supervision of contracts as directed by the city manager. Such tasks shall include, but not be limited to, monitoring contract amendments, obtaining applicable insurance certificates and monitoring applicable progress, plan and implement processes for the ongoing protection of the city's interests, recommend and implement policies and procedures to provide for compliance with laws related to bidding, contracting, and purchasing as set forth in the State of Georgia Code and regulations by examining the applicable laws and developing procedures for bidding, contracting, and procurement processes. Ensure all contracts are reviewed by the city attorney as required by Section 3.08 of the City Charter. Ensure council is notified as soon as reasonably possible of all upcoming and active competitive procurements. Ensure all procurements valued at $50,000 and above have council approval. User responsibilities include determine need. The user is responsible for determining the need for a material or service and providing appropriate documentation and justification, including a purchase requisition. Determine funding. The user is responsible for providing proper funding. Specific budget account numbers must be on the purchase requisition. Determine specifications. The user is responsible for determining the quantity, quality, dimensions, duration, and all other necessary specifications essential to the determination of what is to be procured. The specifications must, where applicable, conform to the approved city standards for identity and continuity. Purchase requisition. It is imperative that the user transmits its need to the purchasing agent. The purchasing agent can purchase supplies and services on the basis of an approved and completed requisition. A properly approved requisition contains, as a minimum, the following information: complete description and specifications, quantity, need date, lead time of at least 1 week must be allowed, estimated cost, freight, complete budget account number, previous purchase information or quotation if known or suggested vendor or vendors, authorized approval of department head and division head, authorized approval from the budget finance department. The user is responsible for advising the purchasing office within 24 hours after receipt or within 48 hours if the items or services are found to be unsatisfactory. This is to be done in writing on a receiving report. Environmentally preferable goods and services. In determining which goods and services to purchase, the city shall procure goods and services which contain, whenever practicable, the highest percentage of post-consumer recovered material, the highest percentage of total recovered material available in the marketplace, and reduce waste in the manufacture and use of products and packaging purchased by the city. In determining which goods and services to purchase, the city shall integrate environmental factors into the city's procurement decisions when practicable. At a minimum, the city shall strive to purchase copy, computer, and fax paper with at least 30% post-consumer recycled content. Purchase non-emergency fleet vehicles that provide the best available net reduction in vehicle fleet emissions, including but not limited to the purchase of alternative fueled and hybrid vehicles. Consider purchasing lower emission emergency fleet vehicles with comparable specifications for performance, safety, and fuel availability during emergencies as conventionally powered emergency fleet vehicles. Purchase at least ENERGY STAR rated equipment and appliances for use in local government facilities when practicable, based upon considerations of life cycle costs. Purchase water-saving products, including but not limited to high-performance fixtures such as toilets, 1.28 gallons per flush or less, urinals, 0.5 gallons per flush or less, low-flow faucets, 1.5 gallons per minute or less, aerators, and upgraded high-efficiency irrigation systems. Replace disposable with reusable, recyclable, or compostable goods. Consider life cycle cost assessment and evaluate as appropriate the environmental performance of vendors in providing goods and services. This analysis to determine environmentally preferable goods and services may include raw materials acquisition, production, manufacturing, packaging, distribution, reuse, operation, maintenance, disposal of products, or service delivery. Specifically, factors that should be considered when determining that goods or service have environmentally preferable attributes include, but are not limited to, minimization of virgin material used in goods or service life cycle, maximization of recycled materials used in goods or service life cycle economics of goods and services, reuse of existing goods or materials in goods or service life cycle, recyclability, biodegradability, and compostability of goods, minimization of packaging, reduction of energy and fuel consumption, reduction of water consumption, toxicity reduction or elimination, durability and maintenance requirements, and ultimate disposal of goods. For all competitive procurement methods, a local Brookhaven business shall be granted a 5% price advantage. For example, a Brookhaven vendor bidding $100 shall have $95 used to compare their price to competitors. After this price factor is made, subsequent competitive processes noted on the next few slides shall be applied. The next few slides will deal with the various competitive procurements allowed under the policy. Requests for informal written quotes, IWQ, are prepared and issued with the goal of obtaining competitive responses. Public notice is posted on the purchasing agent's internet web page for all requests for quotations in which the value is expected to exceed $10,000. Additional public notice may be provided for solicitations that, in the sole discretion of the city, are of the size, type, or dollar value that make additional public notice appropriate. Quotations are opened by the purchasing agent at the location indicated and on or after the due date indicated in the request for quotations. A split or partial quotation may be awarded if a request for quotations is for multiple goods or services, more than one vendor provides a quotation that meets the specifications for the items, and a price comparison can be made between the items quoted. The award may be split between more than one vendor by awarding to the lowest cost provider of each item or reasonable grouping of items if acquisition, delivery, and other requirements can be reasonably administered. A split or partial quotation award shall not be used under the following conditions: when the solicitation is for an integrated system and the split of the award between components or parts of that system would jeopardize performance, or if the item is part of a system and the performance of that system would be jeopardized if another brand was substituted. Tie quotations are handled in the same way as tie bids. Invitation to bids. Invitation to bids, IFB, are prepared and issued to prospective bidders with the goal of obtaining competitive responses. Public notice, such as publication in a newspaper of general circulation or posting on the purchasing agent's internet web page of the IFB, must be given in a minimum of 14 calendar days prior to the date set for bid opening, unless it can be demonstrated that an urgent requirement for goods or services exists, in which instance the requirement for public notice may be reduced by the purchasing agent. Bids shall be opened publicly in the presence of one or more witnesses at the time and place designated in the invitation for bids. All relevant information, including each bid amount and bidder's name, will be recorded on a summary sheet. Split or partial bid awards may be awarded with the same guidelines and restrictions as those provided for split or partial quotation awards. Tie bids. In the event two or more identical bids are received, the following procedure will be used when the basis of award is low bid. To the extent permitted by law, a tie bidder from a person within the city limits would be recommended to the appropriate approving authority for an award over one without an office in the city. A person within the state of Georgia would be recommended to the appropriate approving authority for an award over one without an office in Georgia. If the procedure on the previous slide does not result in an award, then the tie bidders will be contacted and advised of the tie and asked if they wish to reduce their bid in writing submitted in a sealed envelope to be opened at the time and place stated by the city staff. If one or more of the tied bidders agrees to participate, award will be made to the new low bid. If none of the tied bidders agree to participate, or if the new bids are tied, then city staff shall break the tie by following the procedures described below as necessary. If the procedures in A and B above do not result in an award, then to the extent permitted by law, a tie bidder deemed in the city's sole discretion to provide the most environmentally preferable goods would be recommended to the appropriate approving authority for an award over one deemed environmentally inferior. If the procedures above do not result in an award, then the purchasing agent in the presence of two or more witnesses will flip a coin. Award will be recommended to the appropriate approving authority. Correction or withdrawal of inadvertently erroneous bids is permitted in accordance to the terms indicated within the IFB. However, minor irregularities may be waived by the city. No bid may be withdrawn for a period of 90 days after the time scheduled for bid opening or as otherwise stated in the invitation for bids. Late bids will be rejected and returned unopened. Bids will be evaluated based on the evaluation factors set forth in the invitation for bid, which may include criteria to determine acceptability of goods, for example, inspection, testing, quality, workmanship, delivery, and suitability for a particular purpose. Criteria for the acceptability of goods shall be used to determine whether particular goods are responsive to the invitation for bids, and not to determine the relative desirability between acceptable goods. The city reserves the right to waive any informalities or irregularities of bids, to request clarification of information submitted in any bid, to further negotiate with the responsive and responsible bidder selected for contract award, or to reject any or all bids for any reason whatsoever. If no responsive and responsible bids are received or all bids are rejected, the city may procure such goods and services by direct negotiation as indicated below in non-competitive procurement of goods and services. The bid will be awarded, if an award is made, to the responsible and responsive bidder offering the lowest price whose bid meets the requirements and criteria set forth in the invitation for bid. The bid may require a contract. Request for Proposals, RFP. When the purchasing agent determines the use of an invitation for bids is not practical or not advantageous because of existing market conditions or the type of items required, the city may procure goods, services, or professional services through receipt of competitive sealed proposals. Competitive sealed proposals are solicited through the use of an RFP with the goal of obtaining competitive responses. Public notice of the RFP shall be given in the same manner as procurement described in Section 7, subsection A of this policy. Proposals shall be opened publicly by the purchasing agent in the presence of one or more witnesses at the time and place designated in the RFP. A register of proposals is prepared that lists each proposer's name. Interested persons shall have access to information regarding procurement transactions of the city in accordance with city policy and the Georgia Open Records Act, OCGA Section 50-18-70 et sequentia. All meetings of the City Council as a part of or in connection with a proposal may constitute public records under Georgia law, regardless of any person's claim that proprietary or trade secret information is contained therein. By submission to the city, proposers waive any declaration, the entire response, any solicitation to be proprietary information. The proposer shall designate in the smallest increments possible that part of the qualifications which is deemed to be proprietary. Proposals and all related correspondence are governed by the Georgia Open Records Act and shall be provided to anyone properly requesting same after contract award. The city cannot protect proprietary data submitted in vendor proposals unless provided for under the Open Records law and clearly marked as proprietary by the proposer. In the event the proposer deems certain information to be exempt from the disclosure requirements, the proposal must specify what content is considered exempt and cite the applicable provision of the law to support that assessment. In the event such information is requested under the Open Records law, the proposer's assessment will be examined by the city attorney, who will make a determination. The decision to withhold or release the information will be at the city's sole discretion. Correction or withdrawal of proposals is permitted in accordance with instructions contained within the RFP. No proposal may be withdrawn for a period of 90 days after the time scheduled for proposal opening or as otherwise stated in the RFP. Late proposals will be rejected and returned unopened. The RFP will identify the criteria to be considered and evaluated as the basis of award. Proposals submitted by responsible and responsive proposers are evaluated by city staff based upon the criteria applicable to the RFP. All proposals, or the most acceptable proposals in the discretion of the committee evaluating proposals, will be ranked in order of their acceptability to the city, giving consideration to the criteria. The city has no obligation to award the contract to the proposer who proposes the lowest price. The city reserves the right to waive any informalities or irregularities of proposals, to request clarification of information submitted in any proposal, to further negotiate with a responsive and responsible proposer who has been selected for contract award, or to reject any or all proposals for any reason whatsoever. The contract will be awarded, if award is made, by the city to the responsive and responsible proposer whose proposal is determined in the city's exclusive discretion to be the most advantageous to the city, taking into consideration price, qualifications, and other factors as indicated in the RFP. The RFP will contain the basis on which the award is to be made. If no responsive and responsible proposals are received or all proposals are rejected, the city may procure such goods, services, and professional services by direct negotiation, as indicated below in non-competitive procurement of goods and services. Request for qualifications. Requests for qualifications (RQ) may be used when it is determined to be in the city's best interest to evaluate the experience and qualifications of a service provider without regard to price or prior to considering price. The procedure for soliciting, opening, and evaluating statements of qualifications shall be the same as described herein for competitive sealed proposals. Service providers whose qualifications meet the criteria established in the request for qualifications, at the sole discretion of the city, may be considered for contract award by participation in the completion price negotiation. The city shall attempt to negotiate a fee with the highest-ranked firm. If no agreement is reached, the city shall begin negotiations with the next highest-ranked firm. Negotiations will proceed in this manner until an agreement is reached. Alternatively, the city may, by direct negotiation, finalize terms with service providers who are selected for award based on qualifications. The city reserves the right to reject any or all responses for any reason. Clarification of information may be requested by the city. Invitation to negotiate. An invitation to negotiate (ITN) may be used when the city determines it is in its best interest to commence negotiation of price and other factors prior to recommendation of award, and it is approved by the city manager. An ITN may be used for goods or services when the scope of work is complex or difficult to define, if strict comparison of services or goods required may be difficult because components are likely to vary among proposers, or in any situation in which it is in the city's best interest to negotiate prior to recommendation of award to obtain the product that best meets the city's needs, price, and other factors being considered. The procedure for soliciting and opening initial responses to an invitation to negotiate (ITN) shall be the same as described herein for competitive sealed proposals. The ITN will identify the criteria to be considered during the evaluation of proposals. All responsive and responsible proposals submitted are evaluated based upon the criteria applicable to the ITN. Clarification of information submitted in the proposal may be requested. The city reserves the right to waive any informalities or irregularities of proposals, to request additional information from any proposer, or to reject any or all responses for any reason whatsoever. The city may at its sole discretion shortlist firms that are deemed to best meet the city's requirements, taking into consideration all criteria listed in the ITN, including price. The city may, at its sole discretion, ask for formal presentations from all of the responsive and responsible proposers, or only from those firms that are shortlisted, if shortlisting is determined to be in the best interest of the city. Negotiations will be conducted and may take place in person or via telephone with all of the proposers or, if shortlisting occurs, with all of the shortlisted proposers. Proposers that participate in the negotiations may be given an opportunity to submit their best and final offers. The contract award will be awarded if an award is made by the city to the responsive and responsible proposer whose proposal is determined to be the most advantageous to the city, taking into consideration price and other factors as indicated in the ITN. The city has no obligation to award the contract to the proposer that submits the lowest price, though justification should be documented. Multi-step solicitation. The city may initiate one of the multi-step solicitation processes described below when a. In the city's discretion, it is impractical to prepare an adequate or complete description of the goods or services desired, due to insufficient data, uncertain requirements, unfamiliar market options, etc. B. The city desires to identify a field of qualified bidders, proposers, goods or services out of a broader field of bidders, proposers, goods or services. Or C. The city believes a multi-step process would best serve its purposes. Consecutive multi-step process. The city may request unpriced proposals or statements of qualifications to be evaluated based on the criteria in the RFP or the RFQ for purposes of identifying one or more desirable or acceptable goods, services, or professional services, or for purposes of identifying a field of at least 3, if possible and available, qualified or most qualified bidders or proposers. The city may request demonstrations, samples, or may conduct interviews with proposers to aid in the identification of desirable or acceptable goods, services, or professional services, or in the identification of qualified or most qualified bidders or proposers. In the event the city requests demonstrations or samples, the city is not required to seek or permit demonstrations or samples of goods or services deemed by the city to be less desirable or acceptable than other goods or services for which proposals or statements of qualifications were received. In the event the city conducts interviews with proposers, the city is not required to interview any proposer deemed by the city to be unqualified or less qualified than other proposers. After identifying a field of most qualified bidders or proposers with the capability of providing the desirable or acceptable goods, services, or professional services, the city may either follow a competitive award solicitation process among the field of vendors identified as having the capability to meet the city's requirements for the procurement or by direct negotiation, as indicated below, in non-competitive procurement of goods and services. Simultaneous multi-step process. The city may request that priced proposals be submitted in 2 separate envelopes, with pricing information contained in one envelope and all other requested information contained in the other envelope. In such case, proposals will be evaluated in accordance with the requirements set forth in the RFP, initially without regard to price and without opening the envelope containing pricing information. Based on such evaluation, the city will establish a field of at least 3, if possible and available, qualified or most qualified proposers. The city may conduct interviews with proposers to aid in the identification of qualified or most qualified proposers. The city may conduct interviews with the proposers to aid in the identification of qualified or most qualified proposers. If the city conducts interviews with proposers, the city is not required to interview any proposers deemed by the city to be unqualified or less qualified than other proposers. After establishing a field of qualified or most qualified proposers, the city will open the pricing envelopes of only the qualified or most qualified proposers and evaluate such pricing information in the manner described in the RFP for purposes of recommending making an award. For example, most advantageous proposal, price, and other factors considered, or low price submitted by qualified proposers. In the absence of specific instructions to the contrary in the RFP, pricing information will be evaluated together with all other information required by the RFP for purposes of selecting among the qualified field of proposers the most advantageous proposal, price, and other factors considered. When it is in the best interest of the city to have pre-qualified continuing purchasing contracts because of the need to provide quick response, repetitive services, or a range of services or professional services within a specific field of expertise, the city may use either a consecutive or a simultaneous multi-step procurement process to identify one or more continuing contractors. The purpose is to identify one or more continuing contractors that demonstrate the ability to perform a particular type of service during a specified contract period. The multi-step solicitation shall specify the general types of services required, the selection process to be used, and the selection criteria for award of the continuing contract or contracts. Award of a specific scope of work to a continuing contractor. During the term of continuing contract or contracts, specific scopes of work may be developed and awarded to continuing contractor or contractors by amendment to such continuing contract or contracts, provided that the specific scope of work is consistent with the general types of services upon which award of the continuing contract or contracts was made. When there is more than one continuing contractor available to perform the specific scope of work defined, the process for award of the work is set forth as follows. First, work may be rotated during the contract period between the continuing contractor or contractors that were selected to perform the general type of services required, or second, award may be made to the continuing contractor that is deemed, based on its original proposal, to be the most advantageous to the city for the specific scope of work required, price and other factors being considered, and without regard to rotation among selected contractors, or third, quotations, bids, or proposals may be requested from the pre-qualified continuing contractor or contractors that were selected to perform the general type of services or professional services required. The city may select the continuing contractor whose quotation, bid, or proposal is deemed to be most advantageous to the city to perform the specific scope of work required. Online reverse auction. The city reserves the right to utilize this procurement method when advantageous. The process will be specified in the solicitation documents. A performance bond or letter of credit may be required for any solicitation that includes services to be performed after consultation with the city manager and others as necessary. Prior to the consummation of the purchase by the city of goods, services, or professional services, such purchase shall be approved by a person having approval authority over such purchase. The purchasing agent shall provide and update all forms to procure goods, services, and professional services as needed. These forms will typically be housed on the city's shared drive, or you may request them directly from the purchasing manager as needed. The provisions of the non-competitive procurement section shall apply to the procurement of goods and services when competitive procurement is not practical, feasible, possible, or desirable. Notwithstanding any other provision, any contract or subcontract entered into by the city with any person for the construction, reconstruction, or maintenance of all or part of a public road in the city, including but not limited to a contract or subcontract for the purchase of materials, for the hiring of labor, for professional services, or for other things or services incident to such work, shall be entered into in accordance with OCGA Section 32-4-114. The city may acquire goods, services, or professional services pursuant to a sole source procurement. Sole source procurement is available when goods, services, or professional services are limited to one source, or when they must be obtained from a specific manufacturer's dealer and valid competition among dealers does not exist. The user must provide the justification for the sole source procurement to the purchasing agent after approved by the city manager or council. The city may acquire goods and services pursuant to a single source procurement, a procurement made from one person among others in a competitive marketplace, which for justifiable reasons is found to be most advantageous for the purpose of fulfilling the given purchasing need. The user must provide the justification for the single source procurement to the purchasing agent after approved by the city manager or council. The purchasing agent may elect to purchase particular brand name goods or services when the goods or services comprise a major brand system, program, or service previously selected by the city, and due to operational effectiveness, future enhancements or additions, or maintenance or storage of spare parts precludes the mixing of brands, manufacture, etc. Direct negotiation. Following the completion of a competitive award solicitation process above that fails to produce a responsible or responsive bidder or proposer, fails to produce a qualified respondent, or for which all submissions were rejected for any reason, the city may procure the goods, services, or professional services that were the subject of such failed solicitation by direct negotiation with any provider of such goods or services when issuing a revised solicitation is not recommended by the city manager with concurrence from legal counsel. Emergency procurement. The city may acquire goods, services, or professional services by directly negotiating upward pursuant to an emergency procurement. Emergency purchasing situations occur when there exists an emergency constituting a threat to public health, safety, or welfare, or to the soundness and integrity of public property, or to the delivery of essential services, and where the diverse effects of such emergency may worsen materially with the passage of time. It is understood that, from time to time, occasions arise at departments which dictate immediate action to purchase items in order to prevent disruption of operations. Notwithstanding any other section of this policy, when the city manager determines that an emergency situation exists, the purchasing agent may make or authorize others to make emergency procurements for goods, services, construction items, or professional services. The city manager shall make such a determination when there exists a threat to public health, welfare, or safety under emergency situations. Such emergency procurements shall be made with as much competition as is practicable under the circumstances. It is understood that from time to time occasions arise at departments which dictate immediate action to purchase items in order to prevent disruption of operations. Notwithstanding any other section of this policy, when the city manager determines that an emergency situation exists, the purchasing agent may make or authorize others to make emergency procurements for goods, services, construction items, or professional services. The city manager shall make such determination when there exists a threat to public health, welfare, or safety under emergency situations. Such emergency procurements shall be made with as much competition as is practicable under the circumstances. A written determination of the basis for the emergency situation and for the selection of the particular person shall be included in the contract file. As soon as practicable, a record of each emergency procurement shall be made and shall set forth the contractor's name, the amount and type of the contract, a listing of the item procured under the contract, and the identification number of the contract file. If an emergency situation should arise after office hours which requires immediate action on the part of the agency involved for the protection of the best interest of the city, or if a like situation arises on a weekend or holiday, and when it is not possible or convenient to reach the purchasing agent, any purchase necessary shall be made by the official in charge of such agency, and such purchase reported to the purchasing agent within 24 hours. Costs under the competitive threshold. The purchasing agent may acquire goods, services, and professional services by direct negotiation or by some other non-competitive method when the dollar value of the purchase does not exceed $50,000 and a properly executed and authorized requisition is received. Under this non-competitive method, the purchasing agent shall attempt to obtain the goods, services, or professional services most advantageous to the city, price and other factors considered. For goods, services, and professional services under the competitive threshold, but over $10,000, the purchasing agent or user shall obtain, where possible, at least 3 quotes using the IWQ method as outlined in Section 7A. The user may acquire goods, services, and professional services by direct negotiation or by some other non-competitive method when the dollar value of the purchase does not exceed $2,500. Under this non-competitive method, the user shall attempt to obtain the goods, services, or professional services most advantageous to the city, price and other factors considered. The user may acquire goods, services, and professional services by direct negotiation or by some other non-competitive method when the dollar value of the purchase does not exceed $2,500. Under this non-competitive method, the user shall attempt to obtain the goods, services, or professional services most advantageous to the city, price and other factors considered. Direct negotiation and other public entities and co-ops. The city may acquire goods, services, and professional services by direct negotiation or other method involving limited or no competition from a supplier, having a requirements contract annual agreement with any public entity. For example, federal, state, county, city, authority, school board, buying cooperative, etc. For goods, services, or professional services described in such contract and at prices or discounts no less favorable than any set forth in such contracts. Direct negotiation and other public entities and co-ops. Use of state co-op contracts. The purchasing agent may, independent of the requirements of bid process of this article, procure supply, services, or construction items through the contract established through competitive means by the purchasing division of the state of Georgia, national co-ops, that is, U.S. communities, and collaborative purchasing agreements with other local governments when deemed to be in the best interest of the city. 1. Compliance with applicable regulations. All real estate acquisition activities shall conform to applicable federal, state, for example, OCGA Section 36-80-18, and local laws and regulations, and shall be subject to the provisions of the City Code of Ethics. 2. Confidentiality. The City Council and City staff shall maintain the confidentiality of potential and ongoing real estate acquisitions and related information. 3. Formal approval. All real estate transactions shall be formally approved by the City Council in a public meeting prior to the city entering a sales contract. For any piece of real estate for which a sales contract has been signed, the city will conduct at least one appraisal by an independent third party who holds the MAI membership designation with the Appraisal Institute. For land acquisitions, city staff will investigate and identify properties for purchase that generally meet an approved plan or strategy. Furthermore, land purchased with a specific funding source will only be used for such purposes anticipated and/or authorized. If the city determines that the land cannot be used for its intended purpose, the city may dispose of the property in a manner consistent with Georgia law, and funds raised through the sale of the property will be used for future land purchases consistent with the purposes authorized. City staff will work with a real estate broker to gather information and make site visits related to properties under consideration for acquisition. City staff will regularly brief the City Council in executive session on properties the city is considering purchasing to receive direction on terms and price from the City Council. City staff will negotiate for letters of intent with landowners on properties the City Council has provided direction staff with direction on terms and price. City staff will make the letter of intent public on the city website and through a press release within 48 hours of the city receiving a fully executed copy of the letter of intent. City staff will present the letter of intent at a public meeting and at that time request a resolution from the City Council authorizing the city manager to execute a sales contract to purchase the property using the letter of intent as the guidelines for a contract. Public hearing required. City staff will publish the executed sales contract on the city website. City staff will conduct due diligence on the property, including, at a minimum but not limited to, environmental testing, Phase 1 required, Phase 2 and specialized testing if warranted, production of an ALTA survey of the property, production of an MAI appraisal of the property, complete title work on the property, other reasonable due diligence activities as warranted. City staff will present the findings of the due diligence on the property at a public meeting and request a resolution from the City Council authorizing the city manager to execute any and all closing documents to complete the purchase of the property. Public hearing required. The city reserves the right to reject any or all bids if it determines such rejection to be in the best interest of the city. All awards for amounts of $50,000 or greater shall be approved or rejected by the council. The city manager or designee is authorized to approve budgeted capital purchases or contracts up to $50,000 following advance notice to council via email for items over $10,000. Council shall respond within and up to 24 hours of such notice, and should the majority of the members not be in agreement with said contract approval, the contract shall be placed on the next earliest City Council agenda for consideration and approval. The user is responsible for making the recommendation for the award following the procedures as identified above. City Council must approve the purchase of any budgeted capital purchase or contract at or above $50,000. The user is responsible for submitting the recommendation for this award to the City Council. RFPs will generally be solicited on a project-by-project basis. The user will submit the scope of services to purchasing, who will then determine which of the processes to use. Periodically, the city may be given private, public grants and donations from sources, such as the state and federal government and private corporations. These types of solicitations are more restrictive and may dictate the procurement process and methodology that the city is to follow for an award. Both federal and state procurement policy supersedes cities' purchasing requirements when buying goods and services using federal or state grant monies. Departments should refer to the Federal Acquisition Regulation for guidance on specific federal procurement policies. The final determination of the price and terms of any goods, materials, or services shall rest with the purchasing agent. It shall be the responsibility of the purchasing agent to document all contracts, purchases, agreements for services, and leases, and to maintain said documents consistent with the records retention policy of the city. All agreements or contracts binding the city must be in writing. There will be no exceptions. All negotiations of agreements for goods and services shall be conducted by the purchasing agent. It is recognized that special situations may exist where there is a special need for the user to be involved in the negotiation process. This must be in conjunction with the purchasing agent at all times. The purchasing office will make final recommendation for agreements. It is the responsibility of the purchasing agent to secure all necessary approvals of the city manager or their designee or legal authority in writing when necessary to protect the city and its legal liability prior to execution of a contract or purchase agreement. The purchasing agent may make any authorized purchase for which payment will be made in a current, routine manner following receipt of the goods or services. Procurement by leasing, long-term financing, advance payments or deposits, or any other special non-routine method must be approved in advance by the city manager or their designee. The purchasing agent will not normally provide purchase orders after procurement has been initiated. Purchases must be documented by the user with appropriate requisition and specific budget account number prior to the issuance of the purchase order number. In the case of contracts other than routine purchase orders, leases or service agreements, either new or renewals, the approval process is necessary. All such documents will be forwarded to the purchasing agent. The purchasing office will acquire the necessary approvals prior to execution of any agreement, contract, or lease through the city attorney's office. When said contracts, leases, or service agreements are up for renewal or expiration, the purchasing agent will notify the user for approval to either maintain the contract or bid a new contract. The purchasing agent will be responsible for maintaining a file of all current contracts, leases, or service agreements. The purchasing agent will review the contract for form, completeness, insurance considerations, legal implications, and any other items dictated by each situation. The contract will then be sent to the user and approved by the department director and returned to purchasing. The purchasing agent will be responsible for having the contract signed by the city manager or their designee after it is signed by the vendor. Once the contract is officially executed, the original of the contract will be filed in the city clerk's office. Once a contract is awarded by the city, the contract may be amended without the necessity of rebidding such contract, provided the original contract amount and the scope of the contract is not substantially altered. The purchasing agent will review all change orders and adjust encumbrances as applicable. Change orders will be processed to correct the account distribution, quantity, addition/deletion of line items, change in description and unit price. If a quoted price of the change order is up to $50,000, the requisition will be sent to the finance director and city manager for approval, following advance notice to council via email. Any requisitions with a change order at or above $50,000 require city council approval. The department cannot use the change order process to circumvent the purchasing policy. Change orders cannot substantially change the scope of the contract. The purchasing agent and the user share the responsibility to ensure the quality, delivery, and payment of required goods and services. Final adjudication of any dispute between the vendor and the user shall be made by the purchasing agent with appropriate input from the user. In most cases, contact with vendors regarding the contract will be by the purchasing agent and in conjunction with the user as necessary. All vendors must coordinate with the purchasing agent before visiting any other department regarding the contract. All visits regarding the contract must be made with the knowledge of the purchasing agent, and the purchasing agent has the option of accompanying the visitor. It is recognized that this restriction on visitation will not necessarily apply to those vendors with ongoing relationships, such as computer and copy machine service technicians. All return of goods must be initiated by the user through the purchasing agent. Additionally, all cancellations of or modifications to any agreements must be made by the purchasing agent. It shall be the responsibility of the user to ensure that purchased goods are received, inspected, and verified as to condition. Since the department head signed the purchase requisition, that person cannot be the receiver of the goods and must appoint an individual within the department to be the receiver of the goods and services. Any person who is aggrieved in connection with the solicitation or award of a contract may protest to the city. Protesters shall seek resolution of their complaints initially with the city manager. All protests must be submitted in writing to the city manager within 3 business days of award of the contract. The complaint shall specify the alleged act or omission by the city that provides the basis for the complaint. Upon the filing of a written complaint, the city manager, within 3 business days, shall request a response from the purchasing agent. The purchasing agent's response will be returned to the city manager within 7 calendar days. Failure by the purchasing agent to file a response may be considered as evidence by the city manager. If requested by either party, the city manager or designee shall have a hearing on the complaint within 14 calendar days of filing the complaint to decide the merits of the claim. The city manager is empowered to decide to uphold, dismiss, or amend the decision of the purchasing agent. The city council shall approve or reject the city manager's decision. If the party bringing the complaint disagrees with the conclusions of the city manager and city council, the decision may be appealed by filing a writ of certiorari to the Superior Court of DeKalb County within 30 days of the decision of the city council. Protests concerning invitations. A protest with respect to an IFB, RFQ, or RFP shall be submitted in writing prior to the opening of bids or the closing date of proposals. If not done by that time, the complaint or protest is invalid. Stay of procurement during protests. In the event of a timely protest under subsection B of this section, the purchasing agent shall not proceed further with the solicitation or award of the contract until all administrative remedies have been exhausted or until the city manager or city attorney makes a determination that the award of the contract without delay is necessary to protect the interests of the city. Credit cards shall only be issued upon approval of the department head and the city manager. The credit limit for each card shall be established by the Director of Finance. All individuals assigned a credit card on behalf of the city shall be personally responsible for the use and any fraudulent use. The city manager shall maintain a procurement card procedure manual. This manual shall be on file with the city clerk and made available for all users. It shall be the duty of the user to report all excess, surplus, or obsolete materials to the purchasing agent. At this point, the purchasing agent will examine alternatives as to the most advantageous disposition of the items. Items could be refurbished or reconditioned, transferred, traded in on new equipment, or sold by auction or sealed bid, or destroyed. For property over $5,000 in aggregate or $1,000 individually, Council shall approve the request to have the property declared surplus. For other property, the purchasing agent shall present a list to the city manager for approval. Transfer or reuse. The most gainful method for handling an item no longer needed by a department is to transfer it to another department that has a use for the item. Trade-in. In replacing obsolete equipment, it may be financially advantageous to trade in the old equipment. The invitation for bids on the replacement item should call for bid prices with or without trade-in and provide that award may be made either way. Sale. Excess surplus and obsolete items not transferred or traded in may be consolidated and offered for sale by auction or by sealed bid method. Auctions can be traditional or contemporary, including online auctions such as www.govdeals.com or similar websites. The consolidated list will be submitted to City Council for approval before an auction or sealed bid is organized. The property offered for sale will be on an as-is, where-is basis. The sale will be given public notice. Sealed bids will be opened at the time and place announced with the city, retaining the right to reject any and all. To avoid any appearance of impropriety in the disposition program, it will be the city's policy to prohibit the direct sale of surplus property to any city employee, official, or agent. This policy does not prohibit any city employee, official, or agent from extending an offer at a public auction or in the form of a sealed bid. Proceeds from the sale of excess or surplus property will go into the city's fund that held the asset.